Now back to Inside Real Estate. Here's Mike the Realtor.
Hey, folks, we're back. Thanks for coming on back with us. We got Perry Cockerell here in studio, our resident expert in all things legal. His website, perryjcockerell.com, perryjcockerell.com. Perry, how's it going today?
I am fine. Thank you, Mike.
Good.
Nice to see you again.
Good to see you again.
It's been a while.
Good. I know that it has been a while. Well, what do we got for the folks today? What kind of cases are we talking about?
Well, as you know, I like to look and see the real estate cases that come from the courts around Texas, and I go through them and I try to pick two that I think that are important that can be helpful to both consumers and business owners. These two come from two different courts, one at Houston, the other one from the El Paso Court of Appeals, and they involve similar types of contract type relationships that went south. They both involved a piece of property that the seller refused for one reason or another to ultimately close and transfer title to the other party.
Okay.
Although the party, went through and performed their side of the transaction, ultimately led to litigation. A result, one case, the court affirms the result. The other court case, the court reverses part of it, and that's what I want to talk about. But these are basic kind of real estate 101 type transactions that you learned in law school, but they're still common today. I mean, they result in some real serious problems. One of them is simply when you have a sale of contract, the law requires it to be in writing. And that's for the protection of both parties, the seller and the purchaser, and that's very simple. But that's not always the case. And that shows you why it's just best to go through go through realtors, go through the traditional documents.
Right.
Just do that because it's going to be for your own benefit. But here was a lady that worked in a spa. And so the owner of the spa wanted to buy a piece of real estate, and her employee decided to sell them. And so they offered this home for sale, and they prepared a document, but nobody signed that document. But the purchaser, put down some significant money, $73,000 to buy this piece of property on a document that wasn't signed. It doesn't even reference the real estate. And
was this earnest money, like a deposit, or was this?
It was just a contract where they agreed to put up money and to pay off the first lien. Clearly, the seller wasn't paying for it, and they were looking for some money to pay off the first lien. And so the purchaser is really wanting to buy a home for their daughter, not even for them. Nevertheless, they take possession of this property, and then they put about $10,000 worth of improvements in it.
Wow.
And then 2 years goes by. But they actually then take a second document. But this second document is between the same seller who owns the property and then a different purchaser, the daughter. So now you have two documents. One's not signed. Then you have a second one that's not between the same parties.
Mm-hmm.
And then they 2 years go by. And then they tender another $34,000, which was supposed to be used to pay off a second lien on the property. And then what happens? Well, nobody transfers the title. Nothing. They have nothing to show for. In fact, they paid taxes and insurance and things, and the owners had actually got reimbursement on money for that along the way that they had discovered. Well, you can see what happens.
Mm-hmm.
They get an attorney. The attorney says either convey title or give all the property back. And so I can just ask you, what do you think happened here in a case like this?
Well, I would hope that the purchaser was able to acquire legal deed and title, and then that the seller was able to convey it. I would hope. But
and that's exactly what the trial court saw here. They granted $131,277 in damages and $25,000 in punitive damages and attorney's fees. And so the case also involved fraud, essentially. But you can have a contract and you can have a fraud if somebody in this case had no real intention to convey that property, which is what the court found.
Right.
But the rule of this, and we learned this like in the first few weeks of law school, is that it's true that you do not necessarily have to have a contract to buy a piece of real estate. And there's an exception to what they call the statute of frauds, and that's when you pay consideration, and which they did. They paid $73,000 down, and then 2 years later they paid another $34,000 down. So they satisfied the first element. The second element is you have to take possession of the property, and they did in this case. And the third is you have to make valuable improvements on the property. And they did. They put about $10,000 in improvements. So they satisfied the exception to the rule. So I thought it's an interesting, and not only that, they even satisfied the requirements of statutory fraud. The Court of Appeals found there was no intention to convey that property at the time of the original contract. So I'm just saying they ultimately prevailed, but just think how dangerous that is, because they would have never gotten any relief had they not obtained, the services of an attorney who clearly handled this case very effectively,
very well,
and on appeal. But it's just very dangerous. Look at the cost to get there.
Yeah. So the lesson here, folks, is like, look, you do that with real estate here in the state of Texas? Absolutely, you can. It's definitely not recommended. You need to go through the proper channels to buy and sell real estate, have the proper contracts. Go through real estate agents. We use the Texas Real Estate Commission forms that are promulgated for us to use, or use attorneys. Use the proper attorney for it. That's the way to properly buy and sell real estate so that you are protected and something like this doesn't happen to you. Folks that try to for sale by owner, this is a great example of what can happen in for sale by owner situations if you're not doing things the right way.
That's exactly right. And I'm surprised that this kind of issue is just still out there. It's a Rule 101 in law school.
Yeah, people still try to skirt, the norms, and obviously it seems like they were trying to pull one over maybe, on those folks too. What's the next one?
The next one is not very difficult to understand, but it's a brand new one right out of the Houston Court of Appeals. And this involved an undeveloped piece of property down in Houston, a very valuable piece of property. And this developer and the seller got together and decided to enter a contract to convey this to a company that the purchaser owned. Something went wrong in the transaction. The seller wanted some certain requirements to be made, so the opinion doesn't say what really happened there, but for some reason, the seller wouldn't close. The seller didn't go to the closing, so they didn't show up. So there was no conveyance in this case. So similar to the other one, what do they do? Well, they sue to force the conveyance of this piece of property, but at the same time, the purchaser, also sues on the grounds that he lost profits by being unable to develop this piece of property, which is what he tended to do was to cut this property in half and build 2 townhomes. And he just got up on the stand and said that it would have cost me $800,000 to build each one of these, and I would have profited $600,000 on each. So imagine that. It would have cost him $1.6 million to build these 2, and he would have profited $1.2 million. Now, that's all he said. And he said, well, I considered the calculations, the market numbers, the market price, the labor, and that's my testimony. Well, guess what happened? The jury came back in his favor.
Yeah.
And also, the lost property value, it didn't say how much that was. And he won attorney's fees. Now, we're talking about a huge verdict here.
Yeah, that's a huge win.
On a piece of property not conveyed based on the oral testimony of the developer, who said that he'd only done, he'd done these in the past. He'd 20 years of experience. He'd done one of these a couple of years ago. So imagine that. You fail to close. The next thing you know, you have a $1.2 million judgment and above. on lost profits. What do you think the Court of Appeals did on this?
They, I hope, reversed it.
They certainly did. That this was a little bit too much.
Yeah, to me, that's unbelievable. How you could sue the seller for not closing. To me, this is just a deal that went south versus, okay, hypothetically, I'm going to build these 2 units, and here's what I'm going to profit, and now you owe me all this because it's a loss. Well, none of that even happened because he hadn't even started construction. He didn't acquire the property and did not start construction. So essentially, how can there be any damages? This is just a deal that went south, right?
That's correct. And imagine the pressure of this litigation. You'd have to stay this judgment on appeal would have been a huge amount of money. But it really comes down to some simple things. The Court of Appeals analyzed a number of cases, and lost profits are recoverable, but you have to do more than get up and just testify. One person orally testifies that, well, I would have made $1.2 million, and I'm an expert, and I'm familiar with the market, I'm familiar with the labor, and I'm familiar with the material, and that's it. Okay, the court says you must provide a model for how lost profits are determined. Then you have to support that with factual assumptions. And then you have to show that that model is reasonable. And this $600,000 per unit was just nothing but a general statement. It had no substantive facts. It didn't identify what assumptions were used, and there was just no explanation over how any of these assumptions are reasonable. So
what's amazing to me is that this got past the jury, and the jury, went in favor of this lawsuit to begin with. I mean, I'm having to think, okay, clearly they didn't understand what was going on, or what.
You just don't know what the jury's thinking, and they're not passing on what they call legal insufficiency. This is where courts can set aside verdicts if they're just legally insufficient.
Yeah.
And it's possible to recover lost profits, but I'd say you clearly have to have more than just your client getting up there and saying, I lost $1.2 million. I factored in all these factors. You'd need some type of accountant who could draw data and say that, and draw a line, or he'd have some sophisticated historical data showing something over time. You'd have to have probably multiple transactions that this man had done prior to and after that, and then draw some kind of analysis there. You'd have to have documentation. You might even have to have a second opinion from another expert saying that this is reasonable. You'd have to have a lot of information to prove this kind of case, and this is just not one of them. This is just essentially no evidence to support lost profits. But the court did sustain the other aspects of the judgment, the market value loss, which they didn't say what that was, and legal fees. So the court, that's what a court of appeals can do. It can remove part of a judgment that is not supported by evidence. So,
okay. Well, those are 2 extremely interesting cases. Some of these things are hard to believe, but true. Folks, we've been talking with Perry Cockerell, a resident expert here on the show in all things legal. His website, perryjcockerell.com, perryjcockerell.com. And, of course, don't forget to catch his latest book, A Private War, which is available on Amazon.com. And he's working on a new one, a sequel as well. So, folks, we've had a great show here inside Real Estate. See you next week.
The preceding program was furnished by K1 International, LLC, and is responsible for its content.
Neither the hosts nor the guests or contributors of the show Inside Real Estate with Mike Kruizinga are attorneys, CPAs, tax advisors, or investment advisors, and are not providing legal advice during the course of the show. During the course of the show.